in a compliant way. And also, if you have any questions, please let me know. I'll try to handle them at the end of the session. Also, if you want to share your name, what you do, and where you work in the chat, please. So today we will talk about the importance and the implications of the data protection regulations in the age of AI products. So you could probably agree that there is no AI wouldn't exist without data, in particular personal data. And while that dependence is both a strength and its weakness, the regulations basically cannot keep up with the development of AI, which increases the risk of mishandling such information. So for AI companies, the data protection isn't a checkbox. It's actually a foundation. And it's not only, just fines, it's also about, what it may cost to, your investors, to users and their trust. And in this session, we'll try to explore, that good privacy compliant practices are not just, just about staying compliant. It's actually, driving, smarter AI and faster AI innovation. A little bit of some statistics here from the Stanford AI Index from 2025. So actually 68% of AI teams use third-party data without documenting consent, which naturally leads to major incompliance gaps in the origin of and the legality of such training data. We also seen an increase in regulatory requirements for AI products, and not necessarily just for AI products alone, but for generally products. But AI is also, you may say, is affected by this. So you can talk about the EU AI Act. We can talk about the GDPR here. We can squeeze in the Digital Services Act, Digital Markets Act. And what we've also seen, that there's been a drop in the public trust in AI tools, at least in Europe. So as the AI tools expand, they grow, then their number increases. The interesting thing that the trust falls behind this. And about AI and data flows, which is very important for us to look at from the privacy perspective. We want to understand, well, what happens with the data throughout its whole life cycle in any AI product. And basically, we have a couple of streams. We have the upstream, which is from the builder's perspective, right? We collect data sets. It could be text, it could be image, it could be behavioral data, and is often generated from public sources or user-generated content or enterprise data. The next step would be to actually filter out the data, to clean, to annotate it, and to structure it in a way that the model can learn from. And then the next step would be to actually use this data and to train the model based on this data. And the last step would be to store it in a compliant way and to test it internally for any accuracy problems or bias. On the other hand, we have a downstream perspective, which is the user perspective. So he inputs his personal data. Well, it could be, it could be queries, could be files, it could be his actual usage, how he uses the platform. Then he might receive a decision, real-time based and automatic decision. Could be like product recommendations, could be health insights if he provided health data. If he's applying for a loan, let's say credit scores, or if he applies for a job, job screening results. There might be some collection of feedback through the model. Let's say, was this helpful to you? And the data is being collected. Okay, this was not helpful. And of course, there's always this integration with, almost always there's this third-party integration or API calls where a third-party company is involved, which brings additional risks to this flow. So when each each of those touch points, if not supported by these compliance steps, will be risky, right? We are talking about being transparent, so telling the user what you'll be doing with the data, valid consent capture on legal basis. So you want to identify the appropriate legal basis for this. It could be consent, but it may always be a legitimate interest, which is another legal basis, or it could be contractual obligation in case you need to supply this data, to receive this data to provide the service. Another would be cross-border data transfer. Whenever you use a third party from another jurisdiction, which may not be in the EU, let's say the US, which is a common situation. It's also very important that you have those safeguards, contractual, but also technical in place. And also clear, internal documentation of what's happening with the data, to boost user expectations. So, those data flows, they really trigger some legal risks. And let's, have a look at some, real world examples and how, certain product or certain service can be potentially in violation of the data protection or AI rules. And here we have scenario A. We have a training model that we scraped third-party data. And we are looking at Article 6, right, which is about having a legal basis, right, a legal possibility to process this information, which is a common issue with publicly scraped data sets. We can either rely on consent, which is difficult to obtain and sometimes is impossible, or we can rely on legitimate interests, which allows us for some flexibility. And when it comes to Article 9, which concerns biometric or sensitive information, and when that data is collected from scraped data sets, they typically require a higher threshold, which is the explicit consent. We also have scenario B, where a company wants to deploy AI features with user profiling. Well, profiling is when you analyze someone's behavior, skills at work, or what they do, how they live. That is considered profile. And profiling is, from the privacy perspective, is quite risky and requires a data protection impact assessment. And skipping it risks audits and delays in enterprise deals. In terms of EU AI Act, we know that profiling systems can also be considered a high-risk system, which require quite a lot of things from the company, like very strict transparency, documentation, conformity assessments, human oversights, and all of that. So user profile is something to be taken with caution and should be looked at from the GDPR, but also EU AI Act perspective. User transparency during AI interaction. This is a basic one, but really not a lot of companies follow this. You really want to comply with Article 19, which is about transparency. You want to explain how AI is being used when processing personal data of your clients, of your users or consumers. And a second thing is you can only use the data for the purposes you stated. If you want to use it beyond the original purpose, let's say you want to train a model with support logs, you need to find a way to do so, and that could be, let's say, a clear consent. And the lack of that would be risking legal exposure. And let's maybe have a quick recap at the common violations that happened when using AI products, when developing AI products. That would be failing to meet data minimization and purpose limitation principles. So which means we process more data than we need. We also, the most common one is not to have a lawful basis for data processing. I will We'll look at some examples, real-world examples on the next slides. Processing sensitive information could be biometric, health data, political opinions without explicit consent from the user. And the lack of transparency in user handling, something we just mentioned. And if you, for example, do not conduct special assessment for profiling or high-risk systems. And according to the EU AI Act, it's also about missing transparency and risk controls that are required for high-risk AI systems. Let's have a look at some examples where companies really fail to abide by certain privacy rules. And the first one would be Replica AI. Well, the Replica AI is basically a service that allows you to chat with an AI girlfriend or boyfriend or friend, for that matter. And what happened there is that people started complaining to the FTC, the US regulator, that the chatbot was basically love bombing their users, which really increased their I don't know, addiction to this software, to this chatbot. And this was considered to be a little bit deceptive, but also not fair to the user. Another example, you may have heard about it, it's Clearview AI. Clearview AI, they processed biometric information. So your face is maybe my face for the purpose of identification. And when processing facial data, you most likely use biometric information. And biometric information is a sensitive category of data for which you need a special permission or special legal basis. And I think the fine was there about 20 million euros, if I remember correctly. And also the well-known OpenAI, which was investigated by the Italian regulator for the failure to define a lawful basis for the processing the data of the people, and also transparency how they process the data. I think the fine there was about 15 million euros. Yeah, that's so you can see it's kind of clear that you cannot really get away from data protection. It's gonna come down to you if you're not at least interested about this when building your AI products. And what can help you here is having an experienced data protection officer who will act as a link between you and the regulations. They typically help you transform legal obligations into a product architecture to make sure that your product is built from scratch in a compliant way, monitor whether the data, personal or sensitive, is processed lawfully, build privacy programs and documents such as records of processing activities, data protection impact assessments, and internal policies. And finally, in just ensuring compliance throughout the whole life cycle of your AI product, starting from training, deployment, and also its maintaining it. Let's have a look at a few examples of risk mitigations or mitigation measures in AI data flows. And the first one would be scenario number one, where the AI productivity tool processes work emails of employees. So in this case, for the DPO, he must, among other things, of course, ensure the purpose limitation principle so that the data is not used for a different purpose other than stated in the privacy notice. And if it's used, then for reuse for another purpose, we need to come up with a valid reason to do so, and maybe permission or consent. The DPO verifies that the employee data is processed for productivity insights and does not inadvertently monitor beyond scope. Is something what I mentioned before, and also because it does look like and appears to be like a profiling case, we want to conduct DPA to assess the risks and mitigate mitigate them, potential either removing them or at least reducing them so they become really minimal. And the second case would be a customer service chatbot that uses a third-party LLM and customer data. So here again, we need to look for an appropriate lawful basis for the processing, which could be consent. It could be a contractual necessity if it's really necessary for the contract to happen, or legitimate interest. So your legitimate interest as a company or the interest of the user maybe perhaps in having this processing taking place. Because they're using a third-party LLM, so third-party provider, the DPO must help with the audit of the service provider and enforce the data processing agreement. So the liability for any misconduct of the data or mishandling of the data will be on the sub-processor, the processor. And also the DPO will have to, of course, look at the disclosures in the chatbot UI, clearly indicating that, it's an AI-generated response and explains, that it can be not super accurate or autonomous. So you need to, check it for accuracy. And scenario number 3, we have an AI recruitment platform that scans candidate resumes for matching. And in this case, we want to really look at the fairness principle and data minimization. We don't want the product to use any sensitive categories of data like ethnicity and age. We don't want the product to be biased, and maybe it's even better to comply with the data minimization principle and fairness to exclude those categories from being even assessed. And finally, the DPO must help with enforcing transparency requirements so the candidates, they know how the AI was influencing the outcome. And additionally, I would add that we want to kind of always involve human in this situation. We don't want the machine to make a decision based on its own opinion. And we want the human to be eventually responsible for, okay, we're not going to accept this resume, where we're not going to push it to the next phase. It has to be the human that finally makes the decision. And we have scenario number 4. And here we're talking about an AI tool for predictive maintenance in manufacturing. And here we want to work on some technical measures. Here would be pseudonymization of the machine and worker data to use for prediction. We want to align the data retention with industrial and safety regulation requirements. And in case if the software we use are being transferred abroad, say from the outside of European Union, we want to review the cross-border transfer agreements, potentially implement standard contractual clauses, or look for a different provider. And we have a scenario number 5, the last one, and that would be an ad tech AI tool that is tailoring learning paths of its students. Here we want to, of course, look at the age-appropriate consent, because lots of those tools are being used by the children, and parental controls for such underage users. Also, we want to potentially consider if we need to conduct a DPIA, because we have a match here to have this requirement in place, which is, first of all, profiling, but also we are monitoring the behavior of children. And finally, enforce safeguards around emotional analytics and retention of sensitive educational records. Yeah, so the DPO does not just identify issues. They really help build products from scratch that are really privacy compliant, privacy oriented, user oriented, and depending and of course, it all comes down to the industry and the data flow. So it has to be a very tailored approach for each specific case. And I would also say that the risk thresholds are different for each company. So it's also possible to be very flexible in this case. And so what we at Legal Knows Help, we offer a virtual DPO service, which is really, really tailored to AI startups that operate across different jurisdictions and borders. They either deploy or plan to deploy high-risk AI systems, but not even high risk. It could be low and medium. It does not really matter as long as you process personal data within your AI system, that already creates some risk. And if you need a proactive privacy by design guidance, that would, something that your DPO would be really helpful. And what we notice, if you lack, in-house legal capacity or bandwidth, that's where the DPO will really, really come to help. So what we help, we help with data flows, flagging, identifying different risks, aligning your AI system with the GDPR, EU-AI Act, if necessary, creating and maintaining the documentation necessary for compliance, ROPAs, DPAs, and data protection agreements. And we support with audits, investor diligence, and go-to-market plans. Yeah, I think we're good to go to the Q&A session. I think there were some questions here. Let me see. I do not really have any questions, but I do not see any questions. Victor, do you know if we have any?
Hi, Bogdan. Yes, we do have questions. We have three. You can't see it on your end.
I think, give me a second. Oh, actually, I can. Yeah, I found it. I will then start with the oldest one. Okay, regarding the recruiting example and having human in the loop, aren't humans the problem when it comes to bias? That is true. It's a really good point here, but I think AI works best in combination with humans, which is also the other way around. Humans work better if they employ AI. So I think when both are involved, there's a higher chance of having a better result. In this case, a more compliant result. So that's, yeah, thanks for the question. And the second question from Neil, whose jurisdiction does this fall under, where the server is hosted, where the company is headquartered, or where the majority of users reside, and where the owner of the company resides? So I would say you want to first look at where you're based, the company is based. If you're headquartered, let's say in the EU, there is no question as to, that you have to follow the European rules. If you're based, let's say outside of the EU, let's say Singapore, but you do have users, maybe not the majority, but at least a significant portion of such users in Europe or the US, you want to look at the regulation that is local to this, and yeah, basically your residence and also where your users come from. So those are the two things that are very important here. And question from June. So many of the concepts you mentioned, such as lawful basis, purpose limitation, also apply to other processing activities that not involve AI. What do you think makes AI unique or riskier, whether in the context of developing of an AI product or using AI products as a service provider or processor? Very good question, John. Thanks. I think what it boils down to is that, first of all, we can delegate certain decision-making power to the AI, right? When we're talking about non-AI products, the decision is usually based or involves people. AI makes decision on its, let's say, own, of course, based on some data it's been trained on, and it may make mistakes just as humans. And the second thing would be that there is not much transparency as to how the AI operates. So there's no clear understanding, okay, why the AI made such a decision. Ideally, there should be, and that's why the risks are higher, because we don't know why AI made such a decision. So we can kind of understand why the human made such a decision, but and they can explain. But for AI, you need to look at it deeper. And question from Hans: what are your thoughts on zero knowledge proofs like Chainlinks and Deco? To be honest, I'm not very familiar with this. I'll definitely need to look it up. I know what the zero knowledge proof is, but not sure about Chainlinks.
Okay, so I want to
And
interject here. Sorry, Hans. I think your question is relating to like Web3 and crypto, if I'm not mistaken. Please, we would be answering. We could answer this question, when we have like a session on privacy compliance, in relation to DORA. Next week, 28th. So please feel free to attend that and repeat this question there. And our expert on Dora, who is well knowledgeable in crypto and Web3 aspects, would be able to answer your question. Thank you.
Thank you, Victor, and thanks, Hans. And I think the last question here is from Lev, and how do we as lawyers drive the importance of these measures in AI native teams who want to move fast? It's a very tricky question. It's first of all about the company culture, and if the company really disregards any sort of regulation, that's already, I would say, not a red flag, but at least a yellow one. But if you want to some convey or communicate your point, you probably need to rely on numbers and facts, and I think that's what non-legal teams usually like, or at least they take into account, is that you provide them with facts. Okay, this company was fined for this, and this. It's not just something that it's not an issue that will never materialize, but you need to give an example, real world examples where a company was struggling, or was found guilty of some, I would say, crime in brackets. So as long as you have the numbers, you have the facts, it will be easier for them to understand you and your concerns. And another question from Neil: as an AI startup in healthcare, what are the 3 things I can do to mitigate risks? Sign up to anything, install something. I think one thing you can do is, of course, talk to us while we offer free consultation on our website. We can always, talk about your situation, because to be honest, I don't know, I don't have much context about your product, but it's always, at least you want to be to self-educate yourself. You want to research a little bit to understand the whole context, the whole risk situation that may arise from you handling sensitive information, which is the case in healthcare, and creates even more risks comparing to products that do not use any sensitive information. But thanks for the question, Neil. I think, did I miss any other questions? I think there was a question if it's possible to receive the recording. I don't know, Victor, do we offer this?
Yes, you will be getting the recording. That's why it's been recorded. So everyone who joined, you'd be getting in the registration landing page. We did say that post webinar we're going to be sending an email. You're going to be getting access to our EU AI risk assessment tool, our compliance checklist, as well as the recording of the session. So please look out in your inbox for that. Thank you.
Thank you, Victor. And I think June has another question. I think she's in the process of typing. Yeah, also please let me know if this webinar has been helpful for you. It really helps to receive any sort of feedback. And thank you all for your great questions. I think they're really good. And yeah, thank you. June, okay, I see the last question from her. Do you think it makes sense to limit the training of the AI global model on the provided data since the internal AI models trains on it? I think your question is about whether there's, from the privacy perspective, is it better to use the internal data, the data that we collect as a company, in comparison to the data that we can extract from different resources, maybe public domains or from third party or third parties? Is this probably the question? I think from the privacy perspective, it is definitely much more lighter in terms of risks, because you already have a relationship with your, let's say, users, with the data you're handling, and it's much easier to train on this information rather than taking from outside, because in that case you really need to make sure that that data is, let's say, fully anonymized, or you have consents and permission to use this information, which is, as I said, it's kind of a big problem for AI products, is to make sure that you're training on the data that has been legally obtained. Yeah. When using an AI tool, we prohibit them from training a model on our data. Oh yeah. Well, definitely it's yeah, definitely you want to do so. If I understand your point correctly, you want to, when using an AI tool, from the contractual point of view, you want to make sure that those AI tools are not training on your data except for your own purpose. So it's okay if you direct them, if you instruct them to improve your own algorithm, but not the AI tools they develop independently, or they will be then providing to other customers. So yes, it's okay as long as they follow your instructions, but not for you don't want them to misuse the data and use it outside of the contract with you. Thanks for your question.
Okay, so I think that that's all the questions for now. So thank you everyone for your time. Bogdan, do you have anything else to say before we, I think we're getting, close to the end of the session.
Not really. I just want to thank you all for finding the time to join our webinar, to ask some questions, and I will be really happy to see you on on a call. If there's something you need help with, I'm always available. Also, you can find me on LinkedIn. Yeah. Have a nice rest of the day, and yeah, I hope to see you maybe soon.
Okay, thank you everyone for joining. So like I said, we'd be sending you an email with the recording, as well as other bonuses as thank you for joining the session. Equally, in the chat box, I dropped the link to the form that you could fill out to get in contact with the team as well. So yeah, thank you everyone for taking out time to join us, and I hope that it's been an interesting and insightful session, and we'd keep the conversation alive, speaking about, because it's we're in the age of AI, as the topic rightfully says, and data protection. We want to ensure that while we process our data in our AI products, we are doing so compliantly. So yeah, thank you everyone, and enjoy the rest of your day, and see you when next we see. Take care. Bye.
Bye bye.